Thanks very much, Rochelle, and welcome to the webinar. We'll be discussing navigating the financial services industry away from the effects of COVID-19. My name is Rob Masson. I'm the CEO of the DPO Centre. It's my pleasure today to be joined by James and Asel. I've got James on the line through the wonders of modern technology from abroad, who's joining us today as well. And I'll ask them to introduce themselves just briefly in a moment. By way of some background, the DPO Centre is the UK's Data Protection Officer Resource Centre. We have a large team of DPOs located throughout the UK who we place into organisations on either an ad hoc consultancy or interim basis, or as part of an ongoing arrangement where we act as your official data protection officer on what we call a fractional basis. That's kind of 1 to 8 days per month. The DPO Centre is now in its 4th year, and in that time we've worked with over 330 different organisations from all different industry sectors. However, we do have a particular strength and expertise across the breadth of the financial services sector. I'll now hand over to James, if you can just give us a bit of an introduction, and then James, if you can, please hand over to Asel, that would be great. Thank you.
Thank you, Rob. Good afternoon, everybody. My name is James Collis. I'm a financial services partner at Squire Patton Boggs, based in London. Squire Patton Boggs is a global law firm. We have offices in 45 locations around the world, specialising in both contentious and non-contentious legal work across multiple jurisdictions. In London, we are particularly focused on beyond the data privacy work that Asel will talk about more specifically in the context of this webinar. We are focused on corporate financial services and contentious work in particular. And we have, as I say, plenty of work which we tend to undertake with other offices across the network on a very regular basis. We have a very substantial presence in the US as well. I won't speak any longer. I will hand over to Asel, who will talk more specifically about her own practice and the data privacy practice that Squire Patton Boggs have. Asel.
Thank you. I'd like to start off by thanking Rob for this opportunity to present together today. As for me, I'm Asel Ibrahimova, an associate in the data protection and cybersecurity practice of Squire Patton Boggs. I'm based in London, and I am part of the team of over 20 lawyers who are specialized in data protection and located in various countries around the world. We have a center of expertise in the US and in Belgium, where we're led by experienced data protection experts, and we provide advice to multinational organizations in relation to global data protection compliance.
Perfect. Thank you very much. So let's start with just a brief overview, just to set the scene as to what we're going to talk about over the course of the next 40 minutes or so. James is going to start us off by discussing the current impact COVID-19 is having on the financial transactions and trading operations. Asel and I will then cover the pressures being put on data management, decision making and governance. We'll cover some of the new risks associated with remote working and especially international data transfers, obviously in the light of the recent Schrems II decision that I'm sure Asel's going to go into in a bit more detail a bit later. And of course, no webinar would be complete without covering at least something relating to Brexit. So I'll be highlighting some of the implications and the issues to consider, and the preparations that your organisation is going to need to make ready for exit day. We'll come back to James and he'll provide us with some insights into what to expect from the new financial landscape and how you can prepare. And then Asel and I will finish off with summarising some of the key takeaways, which will hopefully enable your organisation to reduce its exposure to future privacy risks. Now, clearly, we're dealing with some quite complex areas. We only have about 40 minutes, so do please use the chat function, which I think you should find in the panel on the right-hand side of your screen. Please do that as we go along, and what we'll do is we'll ensure we leave some time at the end of the session, and we'll try and answer as many specific questions as we can. So now, before we kick off, I'd like to ask your assistance, actually. We're going to present to you a single poll question in a moment, and the results of which we'll hopefully be able to revisit at the end of the session. So I'm just going to click here, and I'm going to say start poll. Hopefully you're all seeing that. I'll give you a couple of seconds just to put your results in. But the purpose of the poll really is to identify, which of the issues from the list you see affecting your organisation the most over the next 12 months. Just gives a bit of insight into the way that some of the concerns that you might have. So do please take a moment just to respond to the question, and then following that, I'll be handing over to James to provide us with his assessment of the current situation. Hopefully you've all had a chance to do that. Oh, here we go. I can see some results coming through, which is good. We'll show you the results when we get to the end. So, okay, perfect. Looks like most of the votes have been cast. Still a bit of movement. Excellent. Okay, so I'm going to give you a 3, 2, 1, and then I'm going to end that. Thank you very much, and we'll come back to that towards the end of the webinar. So, James, can I hand over to you to deal with the current situation and the impact on financial services?
Thank you, Rob. Just by way of introduction, I think the first point that we all ought to obviously bear in mind is that what we are dealing with effectively, all of us in our own spheres, is a double health crisis. Obviously, there is a crisis as concerns human health. We're living through a pandemic, and we've all experienced some immediate effect of this pandemic. And at the very least, it's introduced a fundamental change in the way we're all living and working. So far, there have been approximately 18 million recorded cases of COVID globally, and almost 700,000 deaths, although the actual number is almost certainly far higher, with widespread reports of alleged under-recording. And of course, the poverty that results from the situation is no doubt going to lead to a further human health crisis as that flows through into the public health arena. Of course, for this webinar, the topic is more around the other aspects of this double health crisis, which is clearly the effect on financial health. So what are the effects on financial health? Well, clearly we've all seen a very sudden economic shock around about the end of March, the sudden insertion of financial barriers, the fragility of supply chains was laid bare. We saw the resurgence, if you like, of the nation state, the choking off of economic activity, both domestic and export driven, and the very clear strengthening of foreign direct investment controls. The result of all this, which was obviously triggered by the human health crisis, has been a rapid deterioration in our economic climate. Last week, it was announced that the US economy contracted at a 32.9% annual rate between April and June. That's the deepest decline since records began in 1947. That's 3 times worse than the previous record, and that was in 1958. Germany's economy shrank at the fastest rate on record over the same period. 10.1%. The Eurozone has seen the sharpest economic contraction, 11.9%, since records began. In the UK, April saw a drop of 20.4% by the same measure, the largest drop since records began. So we've seen this very sudden, very dramatic contraction in the economic activity around us. In turn, there's been, as a result, an unprecedented level of state intervention. Alongside the resurgence of the nation state, we are seeing extreme levels of state intervention in the nation. These levels of intervention are unprecedented in peacetime. In the UK, the Office of Budget Responsibility has given an indicative forecast that the coronavirus bill will be more than £300 billion for this financial year. And just to put that in perspective, this year, the UK government was expecting to borrow around £55 billion for the whole financial year. It borrowed £100 billion in the first 2 months alone. Now, by some estimates, the US government has committed more than $6 trillion by way of stimulus towards the coronavirus pandemic. Even our own Conservative Prime Minister and his business secretary have been forced to deny that they are communists. Questions from serious journalists. Of course, amongst all this is the topic of data protection and the stress testing that this has put on to data and the need to protect it. Now, I'm not going to talk in detail about that. Obviously, Rob and Asel will talk about that more in a moment. But I think most are agreed that the crisis will only be truly contained when effective therapies and vaccines are available. And in the meantime, we're reliant on measures to limit the spread of infection. And core to all the efforts to contain and combat the virus is data. And the power of data has never been more evident. But alongside that, of course, sits an enhanced need to protect data. And as I say, I'll leave Rob and Asel to talk more about that in a moment. But what I did want to touch on before I hand back to Asel is the financial services industry. Now, in many ways, all of us working in the financial services industry are kind of in the eye of this storm. In many areas, it is providing the interface between the government and the public for the distribution of financial aid. The government has placed high expectations on this industry. And one area where that's been particularly clear has been the government-funded support schemes for business. So, for example, as at the 26th of July, banks who are acting as accredited lenders under those schemes had approved over 1.1 million applications just under one of those schemes alone. That's the government's bounce back loan scheme. That's the smallest of the various schemes on offer. And that number of approvals alone comprised total lending of over £33.6 billion. Now, the point here is that history tells us that those of us who act in these crises are often, unfortunately, judged in hindsight. And this is particularly the case, as was shown after 2008 with the financial services industry. And I'm sure nobody on this webinar, anybody else acting in the industry at the moment, will be more mindful of that dynamic. So all I would say is, and I'll come back to this theme later when Rob hands back to me later on in this webinar, but I think against this very dramatic context that we're operating in, I think it's well worth bearing in mind that the actions that we take in this very tough climate are going to be looked at with the benefit of hindsight. Asel.
I think actually it's probably coming across to myself, but thanks for.
Oh, sorry, Rob.
No, that's no problem at all. Thanks very much for that. Very much appreciated. So let's to the next slide. So I just want to move into the kind of data protection side of things and just start really with an overview of why data protection has become such a huge issue for organizations, especially those from the financial services sector. I mean, data protection laws obviously have been around for decades now, and the financial services industry is of course no stranger to compliance requirements. But the EU General Data Protection Regulation, the GDPR, was still a game changer when it came into force in May 2018, not least because of the new penalty levels that we're all probably pretty familiar with by now, but also because its seventh principle introduced a requirement to be accountable for the data that you process. Therefore, the spotlight, if you like, of ultimate responsibility moved from privacy and compliance, firmly up into the boardroom. So complying with the accountability principle means that it's no longer a viable option to put your house in order after the event. You must now be able to demonstrate that you took all reasonable, what's called organizational and technical measures to mitigate any issue before it arises. So we're just starting to see some of the penalties coming through from our regulator in the UK, which is the Information Commissioner's Office, or the ICO. And it hasn't escaped most of us that up until recently, the penalties that have been coming out have really been dealing with the cases relating to issues that arose prior to May 2018. But of course, recent penalties like that one, the 183 million that the ICO announced that it is minded to fine British Airways, have clearly demonstrated that the new regime that organisations are now required to operate under. Now, the expectation is that, given the dramatic effect that COVID has had on the travel sector, that the final level of penalty is likely to be significantly reduced. But even if it is reduced to the 10% of the 183 million that is being suggested, it's still a sufficiently significant amount of money to gain the attention of most boardrooms. Then, of course, we've got Marriott Hotels. They're in line for a £99 million fine for the breach they suffered for the Starwood Hotels chain that they acquired. This particular case should be seen as a bit of a wake-up call for anybody involved in M&A, mergers and acquisitions, as clearly data protection now needs to be a key factor in the due diligence process. And whilst, of course, indemnities may provide an element of financial cover, it's the brand and reputational damage that has the lasting detrimental effect. Another organisation being put through a similar mill at the moment is, of course, EasyJet. Their share price has dropped to around 1/3 of its February value, in no small part, of course, because of COVID and the effect on the airline industry in general, but equally not helped by the huge data breach they suffered that affected 9 million of their customers. So the announcement of this breach was closely followed by what's called a group action lawsuit, which is where individuals have joined together and are now claiming up to £2,000 each in compensation. Now, the ability to bring a group action is a feature of the GDPR, and clearly, if the no-win, no-fee based law firm is successful in that pursuit, and it's likely to set a precedent going forward where all significant breaches will immediately give rise to similar actions. So what's changed due to COVID-19? Clearly, the issue started with our rather rapid migration to remote working. The data protection and information securities of working from home were really brought to the fore almost immediately. So we had to install new software and systems and security practices and data management protocols and policies and monitoring capabilities. All of these things had to be put into place extremely quickly. And I think it is fair to say that, after the initial scramble, the industry as a whole made the transition reasonably well. However, we will likely start to see some of the liabilities come to light, such as unreported data breaches, compromise of your organization's internal systems through poor home security. You've got loss of visibility and centralized system control. And it's things like incomplete, what are called data subject access requests, where, and due to the fact that personal data is being stored on local home devices rather than centrally in your systems. And all this puts pressure on an organization's ability to maintain control over data and therefore remain accountable for the data that's being processed. Now, the government is, of course, partially to blame for the increased spotlight on data protection issues. This was initially due to the debacle around the now scrapped centralized track and trace system. And now we've got privacy implications being created by making what are essentially small and inexperienced retail and hospitality businesses responsible for the protection of customer personal data. These organizations, they need to return to their place of work, now that the strict duty of care that their employees to ensure that they provide a kind of COVID-safe environment. However, this of course involves recording of sensitive personal data, such as underlying health conditions, temperature readings, things like that. And this of course creates issues around what personal data you're permitted to share with other employees, because you must balance the need to inform employees of who may have come into contact with someone who is showing symptoms, but without necessarily sharing the identity of the person exhibiting them. So it creates some complexities in terms of how you comply in a balanced manner with data protection rules. Now, so far at least, thankfully, significant issues have been pretty few and far between. But of course, we're quite some way off from a full migration back to work. So, Sel, would you like to take the next one?
Thank you, Rob. So with this slide, we would like to remind you of the rules on the international transfer of personal data, and also to update you on the big changes that were caused by the recent CJEU ruling. So first of all, in general, the GDPR prohibits any transfers or access to personal data from the EU to countries outside of the EU or the European Economic Area. These are called, third countries, and there are several ways that could legitimize international transfers, and these are familiar to you. First of all, the adequacy decisions by the European Commission, which recognize third parties as providing adequate levels of protection to personal data equivalent to the EU. And there have been around 13 countries that have received adequacy decisions. This included the US, and the adequacy decision in relation to US companies was partial because not everyone in the US can receive personal data from the EU, only those who have self-certified under so-called EU-US Privacy Shield. The second mechanism for lawful international transfers is binding corporate rules, which are intra-group agreements approved by a European supervisory authority or so-called data protection authority. These are very difficult to achieve, are quite costly, and around 50 companies have been able to obtain BCRs. And the third most probably cost-effective and most used mechanism are the standard contractual clauses. And these are basically model clauses or templates approved by the EU Commission that can be put in place with a data recipient in a third country, and these recipients are contractually committed to provide the level of protection to personal data received from the EU. So on the 16th of July this year, the Court of Justice of the EU delivered a decision that the EU-US Privacy Shield decision by the EU Commission is invalid. And the reason for that was that certain US laws that require mass and indiscriminate surveillance, collection, and monitoring of personal data result in a level of protection that is not acceptable to, is not equivalent to the guarantees provided by the EU. And data subjects in the EU do not have any actionable rights against the US security authorities in case their personal data was not treated in line with European standards. So due to this, the privacy shield no longer is a valid mechanism for transfers to US companies. So this affects around 5,000 US companies, and there is no grace period. And if you rely on Privacy Shield for international transfers of your personal data, you will need to switch to another mechanism immediately. And it's likely that you will be considering standard contractual clauses. So the CJEU ruling also kind of reiterated and stressed the obligation of the parties to standard contractual clauses. It reminded EU controllers that they need to carry out an assessment and verification as to whether the data recipients in third countries, not only in the US, are able to comply with their obligations under standard contractual clauses. This is, to be honest, going to be a new exercise for most of EU controllers, because usually what companies would do is that they would sign standard contractual clauses and put it on the shelf. So what the EU authorities now would like to see is documented assessment as to whether their data recipients are able to comply, or whether there are any local laws that will prevent them from committing to the standards of protection in the standard contractual clauses. So the procedure is as follows. If you, following an assessment with the assistance of your data recipient in a third country, decide that the data recipient is basically able to commit to the obligations, you will document it and you will continue transfers to that data recipient. If the data recipient informs you that, based on the assessment from their lawyers, because essentially this assessment will require an expert opinion from local lawyers. If they confirm that they are unable to commit to the provisions of the standard contractual clauses due to local laws, then you will need to suspend or end transfers to that data recipient. If you, despite the assessment, decide to continue transfers to the data recipient, and you know that the data recipient won't be able to comply with its obligations, you will need to notify a relevant EU supervisory authority. And to those who are in Germany, I just wanted to let you know that the Data Protection Authority in Berlin and the Data Protection Authority in Rhine area have published their statements stating that, in their opinion, standard contractual clauses are unlikely to work for transfers to the US. They're also unlikely to work for transfers to Russia, India, or China due to the local laws in relation to state surveillance. So this is obviously a decision that is going to impact a lot of data flows and will require your immediate attention. We will and all of the businesses that have data flows outside to third countries will need to follow any further guidance from the European Data Protection Board and data protection authorities to see if there is any further information. Rob, back to you.
Perfect. Thank you very much. So let's have a look at some of the data protection specific issues. So it's kind of not surprising that data protection was required to take a temporary backseat in the early stages of the pandemic. And organizations, of course, needed to concentrate on their COVID responses. Now, information security has remained paramount, but urgency around data protection issues, such as responding to things like data subject access requests, have tended to reduce. A DSAR as a request is one of the rights under GDPR. So we're able to request a copy of all of our personal data being processed by an organization. There's a certain number of days that you've got to respond to that. Now, these kind of delays were kind of recognized by the ICO, the Information Commission Office at the time, and they indicated they would most likely be more lenient in response to, or in terms of response times. But that concession is largely expired now. So it hasn't become the new normal. I think there was a kind of basic hope that it might do, but it certainly hasn't. That said, of course, working from home does look as though it's here to stay. So as I mentioned earlier, the need to ensure you remain accountable for all of your processing, whether performed at home or at work, very much remains. Therefore, if your organization hasn't implemented proportionate controls and monitoring capabilities for home working, then you are going to need to do so. But at the same time, you will need to ensure that they respect employees' privacy kind of outside of their work times. So ensure that they are provided with budgets that enable them to update policies, to purchase equipment and provide training, review your kind of information governance and data security practices. You should also ensure that your organization has conducted what are called data protection impact assessments, so DPIAs, on the new systems and processes that you've introduced since lockdown, especially if those are processing what are called sensitive data, such as kind of health data and things like that. So a good example is something like video conferencing. Obviously we're using it now. I'm sure you're all using it in order to communicate whilst you're working at home. But of course, you're probably using it to conduct interviews and disciplinaries and occupational health consultations, and all of these things are involving the sensitive data. And so you need to conduct the DPIA process to demonstrate that you've identified the risks associated with that processing. So, I mean, you may have seen in the recent news coverage, that it brought to light the fact that the government had not conducted a DPIA on the test and trace system. So in effect, any of the processing of personal data used by that system was essentially unlawful. Now, working from home means, practices and procedures will inevitably have changed. Therefore, you need to ensure that your kind of policies and your protocols have been updated to reflect those changes. And at the very least, this will likely involve kind of updating your privacy policy to take into account any new systems or software that you're now using. You'll update your breach reporting and notification processes, and you may need to introduce new policies like what's called a bring your own device policy, which kind of sets out your expectations on employees when using their own devices to access kind of work-related personal data at home. Now, back in May, we published a series of practical tips to help you kind of better protect personal data whilst working at home. And if you follow the link that's shown on the slide there, you should be able to access the full list of them. So I'm just going to move on briefly to the Brexit considerations. So as you're all aware, the UK formally departed the EU on the 31st of January this year. So So Brexit has effectively already occurred, but we are now in the remaining 5 months of the transition period leading up to what's called exit day. This will happen at 11 p.m. On UK time on the 31st of December this year. But up until that point, it's essentially business as usual. The UK has adopted many of the EU's laws, one of which is the GDPR. So what it means is that in effect, we've now got 2 times GDPR, being the EU GDPR and the UK GDPR. Now, for the time being, they're essentially identical, but obviously after exit day, then the 2 are likely to diverge over time. Asel's already touched on it. There is this thing called adequacy. Like any other country that's outside the EU, the UK will become what's known as a 3rd country in respect of EU GDPR after exit day. Now, how much of an issue this is for UK organisations depends greatly on that adequacy decision. So these decisions they're made by the European Commission. They normally take about 18 months to complete. Ours didn't start. We applied on the 1st of February, and we're apparently 13th in the queue. So it's by no means guaranteed that we'll even get a positive decision. I think it's less every day that goes by. It's probably less likely that we're going to get adequacy, certainly by, or at least full adequacy by exit day, which means that there's an exercise of implementing additional contractual safeguards that's going to be needed, and that's going to be potentially with all of your EU suppliers and partners and vendors. And as Asel mentioned, that's most likely going to be through these things called standard contractual clauses. But again, as Asel mentioned, the Schrems II case has rather complicated their use in certain situations. Another stumbling block will be the loss of what's called the one-stop shop. Probably not relevant to everybody, but it's essentially a system that enables your organisation to nominate a single regulator, such as the ICO in the UK, in a single member state. So, and what it means is that if you were to suffer something like a breach, you then only need to liaise with that single authority, rather than having to deal with each and every authority where your data subjects reside. So after exit day, the ICO will no longer play a part in that mechanism. So if you are an organisation that has nominated the ICO under the one-stop shop, then you're going to need to confirm if you're eligible to nominate one of the alternatives from any of the other EU member states. But the important thing is it has to be where processing decisions are made, and that's sometimes the complexity. It's a little bit too much to go into today, but that's the kind of caveat that's involved around it. A fairly important one is EU and UK representation. So there's an article, number 27, in the GDPR that requires organisations to appoint a representative if they are based outside of the European Economic Area, which is basically the EU plus 3 other countries, but they don't have any physical presence inside the EU. So previously it was more kind of US and Asian organisations that are processing data on EU residents, but they don't have an office, if you like, in Europe. They were required to appoint a representative, and it's so that data subjects and regulators can contact that representative in the EU rather than have to worry about language and time zone, all those kind of issues outside of it. So now, of course, that requirement is now going to become necessary for UK companies because we will be outside of the EU. And so if you don't have a presence inside the EU, but you are processing data on EU residents, then it is something that you need to look at the kind of criteria behind as to whether you require one. Now, similarly to the return to work tips mentioned previously, we also published a series of tips to help with your Brexit planning. So again, if you follow the URL that's on the slide there, you should be able to find the full list. So I'm now going to hand back over to James, who's going to deal with the near future and what to expect.
Thanks, Rob. So how do we think the landscape is going to change over the near future? Well, obviously on human health, as we're all seeing in the media at the moment, and some of us unfortunately are probably experiencing, many populous nations are still combating the first wave of the virus, for example, Brazil and India, for example, of course, the US. But for many others, there are ominous signs already that a second wave has arrived. For example, Spain, Germany, also the UK, and others such as Australia. So as we head through into winter, all the professional commentary seems to be saying that we can only expect things to get more challenging on that front. And most estimates that the timing of a vaccine and other effective therapies way off into 2021. So against that context, what about financial health? Well, in the meantime, obviously the economic climate continues to deteriorate. We have examples every day in the media of redundancies and job losses. Yesterday, even if it was part of a restructuring, I saw that, for example, Virgin Atlantic had filed Chapter 11 in the States. Many businesses, especially those in the worst affected sectors, such as retail and hospitality, are either out of cash or running perilously short of cash, to the extent, as I say, that they are still operating. We're starting to feel the effects of the introduction of the withdrawal of the government, UK government support programs in certain key areas, and much of that support is scheduled to taper off over the coming months. For example, the government's job retention or furlough scheme, as it's more commonly known, is scheduled to end on the 31st of October. That scheme was launched on the 20th of April, and it alone is now supporting 9.5 million jobs from 1.2 million employers. And just to put that in context, the total UK employed workforce pre-crisis was roughly 32 million. And of course, as Rob was just mentioning, we're running towards the end now of the transition period ahead of Brexit. 5 months to go, and whether one sits on that debate, we can all agree that the current uncertainty around how things will look the 1st of January is only going to compound the economic hardship that COVID has already brought us. Unemployment is obviously going to be a key theme, as we're already seeing, as businesses start to feel the pressure of the severe recession that we're now in. We can expect further significant job losses, notably, obviously, as the furlough scheme starts to come to an end. And I think the levels of delinquency for debt, defaulting on loan arrangements, including obviously those arrangements that were put in place to sustain businesses through the early part of the crisis, that level will only increase. In fact, in its recent report entitled Supporting the UK Economic Recovery, the City UK business body estimated that by the end of March 2021, there could be up to £100 billion of unsustainable debt held by UK businesses. And they estimate that about £35 billion of that, so about a third of that, comes from indebtedness incurred during the crisis under government loan schemes designed to support business through this period. Indeed, in their major report entitled The Impact of COVID-19 Loan Schemes on Business Banking Dispute Resolution, the Business Banking Resolution Service, they'd surveyed 500 small businesses and found that 56% of them had accessed government-backed loan schemes. That's basically the bounce back and the next smallest, which is the CBILS loan scheme. And of that 56%, 43% said that they did not expect to be in a position to pay that debt back. So it's very clear that as financial institutions and lenders, we're going to see increased numbers of defaults, if not breaches, but certainly stress under those loan arrangements and other financial arrangements. And it's a theme I'll return to in a second, but how we respond to those is going to be very, very important. So this is a big challenge for the financial services industry. but it's also an opportunity. And I think the key to rising to that challenge is to recognize, as I say, all the many dimensions in which the context in which the industry is now operating has fundamentally changed. How has that context changed? And I think before I finish, I just wanted to leave you with sort of 5 thoughts as to how the industry can help to orientate itself through this crisis. The first is to recognize that I think sustainability is more important than ever. As one of my colleagues puts it, the crisis has seen a massive global experiment in carbon reduction. So environmental is going to be even more important as a consideration than it was going into the crisis. Governance, for example, the enforced social experiment, as Rob was just saying, driven by home working, distancing, has only enhanced opportunities, for example, for greater diversity, notably gender diversity, in the governance structures of organizations. So governance is going to be very much a theme coming out of this crisis. And of course, we've all seen the example of Black Lives Matter, and the social dimension and the pressure for social change is going to come even more to the fore as a result of what we're all living through. The second point is, I think that as financial institutions, we are now operating in a climate where there is increased public scrutiny for corporate behavior. And that will only increase further. There is also alongside that an increased sense of community and responsibility that needs to be held, if you like, by businesses. The days of the purely amoral corporation are numbered, if not over, and the importance of the social contract, for example, between the employer and the employees is far greater than I think it's been for a while. Care for the workforce's well-being is just one example that we've seen very much in evidence through this crisis. Now, how we as financial institutions respond to corporate distress and delinquency will define our role, and dare I say it, regulatory treatment for years to come. That's very important because there's no doubt, speaking as a lawyer, that there will be an increased regulatory burden that will be consequential of this crisis. And how the main actors behave through this crisis will directly inform the nature of that burden. And against that context, please remember, as I said earlier, the power of hindsight. And remember that predicted figure of £35 billion of delinquent government debt. And then consider, for example, just with that very smallest of the government loan schemes, that scheme had an 82% approval rate for applications. So financial institutions are in a terribly difficult position. They've been under pressure to act as the interface and to help support, if you like, transition through this very challenging period. But now, if you like, they need to pivot towards the future and navigate their path through this very challenging next phase of this crisis with their eyes wide open to these various challenges and knowing that people are going to be judging them with the benefit of hindsight. In that context, the third point I'd like to end with is decision making. I think this is not only about what decisions are actually taken, but also the way they are taken and being seen to be taken is going to be more important than ever. Particularly in the context of where there are obviously contentious decisions around delinquent debt, for example, and what will inevitably continue to be a very stressed economic climate for a long time to come. The fourth and penultimate point is really the plurality of actors that are now in the financial services industry landscape as compared to, for example, 2008. I think as a result of the global financial crisis, there was, if you like, a fragmentation of the industry, and there was various regulation consequential on that, notably, for example, Dodd-Frank, which accelerated that. But it's meant that the industry is now populated by a far greater, far more cosmopolitan population of actors, if you like. And I think against that context, all of us who are involved in this industry need to be mindful of that in terms of flexibility and cooperation and how those different players, if you like, can interact in a constructive way to work through the challenges ahead. And finally, and really picking up on the theme that Rob was talking about just before, this whole theme of risk management. The world is going to be more uncertain and unstable for a while to come yet, and this only really underlines the need to strengthen risk management structures and approaches within financial services organizations. The key words that I would use to describe that are increased dynamism, so more reporting on an ongoing dynamic basis, more forward-looking risk management techniques as well. And clearly, in the context of the discussion that we're having today, nowhere is that more evident than in the need, in the context rather of data protection. So those are the 5 thoughts that I'd leave you with. Hand you back to Rob now. Thanks.
Perfect. Thanks so much, James. That was very, very enlightening. So I'm just going to, I think Asel's just going to finish off just with a few kind of key considerations, conscious of time, so we'll rattle through these as quickly as possible.
Thank you, Rob. So just to summarize, we are facing very challenging times and need to prepare for a long haul, I guess. And here are the several takeaways. From the financial services perspective, if I may summarize what James said and his 5 points in probably very simplistic, prepare for the upcoming liquidity deficit. Maybe it is quite simplistic, and I'm sure James will be able to extrapolate on the 5 points he mentioned better, and I'm sure you can ask him questions directly. From the data protection perspective, it's important to complete your exercise of mapping your data flows, understanding what personal data you have, where it's stored, and how you handle personal data. As James said, it's quite important that you document your decisions in terms of how you deal with personal data, and the decisions and how you make them is quite important. You also need to review the existing mechanisms for your international transfers following the CJU ruling, and review those. You will need to, as Rob mentioned, consider if you have the ICO as lead authority, you will need to consider if you can argue that you have main establishment in the EU, and if you do, whether the EU authority in that country can be appointed as your lead authority, because the UK is no longer in the system. Further to Rob's point, if you are operating outside of the UK, you will need to consider whether you need to appoint a UK representative, and equally if you are in the EU, if you're in the UK but don't have presence in the EU, you need to consider whether you need to appoint a representative in the EU. Due to home working and increased online activity, increased risk of cyber attacks, etc., you'll need to consider that your security measures are in place, and test any data breach notification protocols, and you need to prepare to the end of the transition period at the end of this year, and by that time have your privacy notices, policies, and agreements, your records of processing, all of those documents updated to reflect that the UK is now outside of the EU. And with that, Rob, over to you.
Perfect. Thank you very much. So that kind of ends the formal presentation part. We've literally got just a few minutes left. So I think there's probably time for just a couple of very quick questions before we end. Asel, this may be one for yourself. Is the FCA responsible for checking the compliance of financial institutions with data protection? Oh, I think you're on mute.
Apologies. Well, the FCA and the ICO have both been issuing joint statements saying that data protection is something that they both will look at. The FCA handbook has data protection principles within it. Protection of customer personal data and security of personal data are at the heart of the FCA handbook. And I think it would be fair to say that although the ICO is the main regulator for enforcing the GDPR, the FCA will consider compliance with GDPR. The FCA has also, in its statements, made clear that the data protection compliance is a matter of board level, and that it expects firms in the financial sector to be paying attention and adding data protection as part of its risk assessment and as part of its senior management arrangement.
Perfect. Okay. And probably just one last one. We've got literally 2 minutes left. So I think it's Helena. She says, we do not have an EU presence as such, but we have EU citizens and employees as customers. Would that mean that we will need to appoint an EU data protection rep as well? So I think the answer to that is the key word there is you've said citizens, and it's actually the deciding word is residents. So if you are processing data on EU residents, then it may well apply. So it's not EU citizens who are living in the UK and working for you. It is EU residents that are residents in another of the 27 member states, but you are processing their data within inside your organisation. And the second factor is that there is a kind of a large scale element to it. So it's not, if you've got 1 or 2 customers in the EU, then it is unlikely to apply. And so there are some kind of, it's not defined. It's the thing about GDPR is it never actually says anything specifically, but there is it must not be occasional. It doesn't. You don't need to appoint if the processing is occasional. So there is a kind of bar, and you have to just work out whether you are above or below that bar. But if you are processing data on EU residents, then it's certainly worth speaking to an organisation such as ourselves who do provide that EU representation service. So, James, do you have any final words you'd like to say just before we wrap up?
Just that if anybody wants to talk about any of the themes that either Asel or I have mentioned during the course of the last hour, then we'd be delighted to engage in any further discussion. But otherwise, thank you everybody for listening, and no doubt there'll be more developments over the coming months, and maybe we could continue this discussion in a few months' time and see where everything's got to by then. But it's been a privilege to be part of this discussion. So thank you very much, Rob, as well.
Thank you. And likewise, thank you very so much to Asel and to James for joining myself today. We hope the content was useful, and we wish you well for the day, and hopefully see you all again soon.
Thank you very much.
Thanks very much. Thank you.